posted to our YouTube channel, so feel free to find it there and share it with whoever you would like. Thanks so much again for joining us today. My name is Rebecca. I'm with AARP Elder Watch, and today's presentation is on power of attorney. This is a fairly brief presentation. We're just going to go over the basics. But before we jump into that, I just want to give a brief overview about what AARP Elder Watch is. We are a 20-year partnership with the Colorado Attorney General's Office. We do education and outreach across Colorado, just like this presentation. We also go in person to various senior centers, community groups, and give presentations, again, similar to this. We have a volunteer staffed fraud victim support helpline. If you or someone you know is a victim of a fraud or scam, feel free to get a hold of us at the phone number below, 800-222-4444, option number 2. And we also have a peer-to-peer financial counseling program that focuses on budgeting and savings, finances after the loss of a loved one, and caregiving finances. So if you are looking for any of those services, we're happy to help. Again, the phone number is 800-222-4444, option number 2. This is an interactive workshop, so feel free to ask questions throughout. You can just pop those in the chat and take notes. I have handouts of this presentation, various budgeting plans, and further resources you can feel free to use today and in the future, and you can find those on our website at aarpelderwatch.org, or get in touch with me and I will send them your way. And I just want to be clear, this is not financial advice and this is not legal advice. Please be sure to consult with a lawyer or a certified financial planner before making any final decisions. This is purely educational, and we are talking about a legal matter of power of attorney today, but this is not by any means legal advice. So let's start off by understanding what exactly a power of attorney is. It is a simple document that gives someone you trust the power to act on your behalf. This person is referred to as an agent or attorney in fact, but usually they're not actually an attorney unless your loved one is in fact an attorney. And I will be using the word agent to refer to this person that has been appointed power of attorney for the rest of the presentation. It can be your child, your spouse, your sibling, or someone else you trust, a close friend or another close family member. And they generally manage financial and or healthcare matters. So choosing an agent is the first step in figuring out who you want to have as your appointed power of attorney. You want to consider geography. So if you do appoint someone that lives further away, it's okay. But if it's possible to choose someone that lives nearby, because some tasks are easier in person. For example, managing finances, having to go to a bank, etc., generally easier in person. Also, healthcare related issues are generally easier to manage in person as well, especially if you need to be attending doctor's appointments or hospital visits for that person. Marriage is another fact to consider. If you are married, it usually makes sense for your spouse to be appointed your power of attorney unless they are ill, and then you want to opt for someone both you and your spouse can agree on that would be able to take on this role and advocate for you in whatever way is necessary. You can have multiple agents. You can appoint one person to take care of financial matters and another person to take care of medical matters. But appointing one person often makes the most sense because this avoids conflict. Should other people be consulted in making these decisions? Likely yes, especially if you have adult children that are filling these roles. You might want to have them, speak to one another before making any decisions on medication, medical care, or finances in general. And then for medical, the person must be over the age of 18. They cannot be on your care team, and they cannot be an employee of a health facility that you live at or stay at. So this is really important just because these things bar them from being in charge of your medical care. The only exception is if someone is an employee of a health facility that you live at or stay at, and they're also your relative, there can be some exceptions there, but otherwise this is pretty strict, and it is to make sure that the person that's making your decisions can advocate for you and be a sort of objective person in making these decisions. So there are various types of power of attorney that are available in Colorado. The two most common are durable medical and durable financial, but we'll also talk about springing power of attorney and non-durable or limited power of attorney as well. Durable medical power of attorney allows an agent to manage your medical care, and this can and oftentimes is the same person that's designated in your living will or your advance directives, which we talked about last week. So if you missed that presentation, feel free to go to our YouTube channel and check it out. There's lots of good information there. We'll cover a bit about it today, just talking more about the medical power of attorney side of things, but living wills are generally very important as well. So this person is going to, again, manage your medical care. There's various roles that go with that, and we'll get a little bit more into that shortly. Durable financial power of attorney allows an agent to handle financial matters for you after you're no longer able to attend these tasks. So this can be anything from dealing with banks, taxes, etc., and we'll get into the specifics again very shortly. Springing power of attorney is a power of attorney that does not spring into effect until a triggering event. For example, after you are declared incompetent by a third party. There are some upsides to this, but there are a lot of downsides to having springing power of attorney. So we'll get into that as well, and get into some of the intricacies of how that works. And then non-durable or limited power of attorney is a power of attorney with an expiration date, and we'll talk about the scenarios where those are necessary. So establishing a financial power of attorney is an important thing for you to do. You generally want someone that is someone you trust, someone you know to be handling your finances if you can't do so anymore. I know a lot of times people have trouble with establishing financial power of attorney in particular because they're worried about someone else controlling their finances. Now, there's some safeguards that can be put into place to make sure that people are not taking advantage of you if they are your financial power of attorney. The first one is making sure that this is someone you trust that will act in the way that you want them to and go by what your wishes are. So the first thing you're going to want to do to establish financial power of attorney is making sure whoever you want to appoint as your agent is of sound mind, that they can make decisions for themselves and then make decisions for you. Sometimes there's, contracts involved with being financial power of attorney that have to be looked over, tax documents that have to be looked over and sorted through, and other financial matters that have to be taken care of. So you want someone that's going to be able to handle this and have the mental capacity to be able to do so. If not, and of sound mind is really up to you as to what that means. But it is actually a requirement in Colorado that they are of sound mind. So you really want to make sure that this person, again, can make decisions that are in your best interests. Then you fill out the statutory form. So the state of Colorado has a form that you can go ahead and download and then fill out with your financial power of attorney information. And then you go through the next few steps that we'll discuss. You can also use software. There's various softwares online that you can use that are basically like little Mad Libs, for lack of better terms, for creating a financial power of attorney. And they take 20 minutes. Generally, they're free. And that can also create your financial power of attorney and medical power of attorney. Or you can talk to a lawyer, talk to a certified attorney in Colorado or whatever state you live in, and have them take care of it. Many lawyers do actually include durable power of attorneys as a part of estate planning. So setting up a will or living trust, a lawyer is already going to include setting up power of attorneys. in those services. So if that is something that you're looking into, that's something you're doing with an attorney already, ask them about setting up both financial power of attorney and medical power of attorney. So you can grant your agent the power to act for you with respect to these areas. And you can, of course, pick and choose, but oftentimes it's easiest to have one person that is handling all of these areas for you. And it's real estate, banks, and other financial institutions. So investment plans, stuff like that as well. Retirement plans, stocks and bonds, the operation of an entity or a business. So if you're a business owner and something happens to you where you're no longer able to make business decisions, oftentimes if you have a financial power of attorney appointed, those decisions will fall to them. Collecting benefits from government programs or setting up those benefits coming in from government programs, and then also sorting out taxes. So after you decide how you want them to manage your finances, you are going to sign the power of attorney in the presence of a notary public. This is not required. You can just get 2 witnesses and be good to go, but it can also be contested in a court of law, and that is where the notary public comes in to save some trouble if things do get contested in court. So this is, again, not a requirement, but is recommended to make sure that this document is certifiable and legal. Store the original document in a safe place. So this is not something you want out on your dining room table. Put it in a safe if you have one. Keep it in a safe place. Maybe 1 or 2 other people know about it, and that's it. Give a copy to your agent. You're going to want to make a copy and give it to the person that you've appointed as your financial power of attorney so they know what responsibilities they have. And then file a copy with the recorder's office in the county that you live in. And also consider giving a copy to your banks and other financial institutions. So they know if XYZ happens and this person needs to take over my finances, here is a legal document that says that they can do so. So establishing medical power of attorney is fairly similar. This means a healthcare agent to make medical decisions for you if you become unable to speak for yourself. There are many legal medical durable power of attorney forms and advanced directive forms as well. If you don't have advanced directives done and you're appointing a medical durable power of attorney, do them at the same time. It takes 20 to 30 minutes. So they're available for download online. They have varying language discrepancies, but they all basically say the same thing. And you go through and make whatever decisions you want about your healthcare to be made. So be sure to choose the one that makes the most sense for you and your situation. You can also get these forms from your healthcare provider or local hospital. And be sure to discuss your values and wishes with your healthcare agent and important people in your life so they know what kind of care you want if you're unable to speak for yourself. And of course, this is outlined in the legal document, but you want to have these conversations before it comes down to someone making these decisions. And you also do want to choose someone, again, that is going to advocate in your best interests and on your behalf in some difficult medical situations. So if you want to, let's say you want to appoint your sister, but in something happens to you and you end up in a life-threatening situation, you know your sister is not going to be able to think rationally about what your care is. Consider having someone else do it that's going to be able to put their emotions to the side for a minute and make decisions in a sometimes very time restricted environment. So non-durable POAs generally are limited in scope. They end if you become incapacitated. They are usually just used for financial matters. They do have a expiration date, so it'll go from X date to X date, and they do not need to be notarized, but it might be smart to consider it just, again, so it's not contested. And usually these are used, let's say I'm selling a house in California, but I had surgery in New York and I cannot leave New York because I'm recovering from surgery to finish selling the house. Then my one-time financial non-durable power of attorney will go and take care of the sale of the house for me and make sure that everything is in order for that to go through and take place. And then at the end of that week or 10-day period or whenever I'm able to get back to California to finish the sale of the house, that the POA is dissolved. And again, it does end if you become incapacitated. So, if something goes wrong or if you're not able to make decisions for yourself, then your durable financial or medical power of attorney, generally, again, in this case, financial power of attorney, will come into place instead of the non-durable one. Springing POAs do not spring into effect until a triggering event. So generally this is incapacitation. And some people, particularly those who are, again, uncomfortable with the idea of giving up usually financial control, decide to use a springing power of attorney. It is generally, again, for financial matters only. If you have medical power of attorney, you're going to usually want that to be one person and not wait till you're incapacitated, because it doesn't go into effect basically until you're incapacitated and you can't make decisions for yourself. There's not really the worry of taking over financial matters before you're not able to make those decisions. Issues do include delays in getting certification of incapacitation, and also what exactly that means. Oftentimes you have to go through, again, a third party, so some sort of doctor. And then there's all sorts of HIPAA and privacy issues. Even if a release form for HIPAA is previously signed, sometimes there's issues with those actually being legitimate or recognized by doctors sharing medical information. And they, of course, want to be covered, so they will not give out information, even if you are potentially the person that's appointed for a springing POA. So that can have all sorts of issues, and then also releasing those records to a financial institution to say, okay, the springing financial power of attorney goes into effect, can have other problems as well. And then again, in the definition of incapacity, that can cause problems too. It is not well defined in most legal scenarios, and it does usually, it's a doctor defining it. So there can be all sorts of issues as to, well, are they actually incapacitated? What does that mean? Can they actually make decisions for themselves? And then having this go into effect. So generally, most people say to avoid springing POA unless you really, really don't trust the person that you're appointing as a durable financial power of attorney, just because it can have a bunch of holdups, and then you run into issues in being able to provide someone with financial care. So that is the one caution for springing POAs, but they are an option. So POAs go into effect immediately after they're signed and witnessed or notarized, but you can instruct your agent to not use them until you are incapacitated. So for example, I am the power of attorney for my spouse, and when I would not use any of those powers until if something were to happen, he's incapacitated. So that's generally how that works. And you can serve in this role for multiple people. A lot of people do. And the power of attorney ends if you revoke the document or when you pass away. And that's why a will is important, and we'll talk about those next week. Keep documents on file with the appropriate parties. So for medical, this is going to be medical providers. For financial, it's going to be banks, financial institutions, and also the recorder's office. And then any attorneys that are involved are going to want to have these on file as well. And be sure to make any updates in the event of an agent's death and reevaluate who you have in these positions about every 10 years or so and see if there's any changes that you want to make as time goes on. So here are a few resources. There's the Conversation Project, which you can find at theconversationproject.org. There's lots of good information there on having these conversations surrounding making these decisions and who should be appointed in these roles and talking to your family about them. Prepare for Your Care has information on power of attorney, advanced directives, and wills, and that's prepareforyourcare.org/en/welcome. The Colorado Judicial Branch has those statutory forms for financial and medical power of attorney, so you can hop on their website and take a look at those, see if the language outlined there is something that you are interested in using. That's www.courts.state.co.us, and then you can search power of attorney and information, more information, as well as the forms will pop up. And then you can give us a call at AARP Elder Watch at 800-222-4444, option number 2. Again, this is the third presentation in our series on preparing for end of life and making sure that things are in order for if something were to happen. So feel free to join us again next week, same time, same place, for a presentation on wills. And that will be the final one in the series, I believe. And then we will be back in May with information on healthcare planning and spending. So if there are no other questions, I hope you have a great rest of your day. If you do have questions, feel free to pop them in the chat or come off of mute. Cool.